and gentlemen. It's a privilege and honor for me to chair this session. When this session was being planned, I was given a topic called corporate governance, but we just wanted to give some shape, and it's my privilege and honor to have with us sterling panel because the topic of corporate governance covers everything that I did in my earlier life, which is accounting, finance, audit, auditors, but it also covers a host of other issues as well. So what we thought we will do in the next allotted 35, 40 minutes is take you through some specific themes that we have developed in the area of corporate governance. And those themes range from a host of topics such as interest of minority shareholders, role that proxy firms have to play. It also covers other issues including related party transactions. We've also seen that in the last couple of years, particularly after SEBI LODR regulations with regard to ESG, that ESG has emerged as a very important facet of corporate governance. And we will try and see as we go along in this discussion to see if we can add more. Mohit, let me start with you first. You are on my immediate right. On minority shareholders, we've seen a host of debates and controversies that have arisen in the last couple of years. Some of them have gone through NCLT, some of them have even gone to the Supreme Court. I just thought if you can touch on that topic and we'll get the others to add what have been your experiences. Is the current framework of law enough to be able to address the minority shareholders? We saw the seesaw a bit insofar as the controversy between the Tatas and the Mistry is concerned, where the NCLAT order was eventually reversed. Of course, they were specific to the facts of Mistry and Tata case. So my question is not necessarily restricted to this one case, but there are many. The Invesco Z controversy also came up. So I just thought we'll start with you first.
Thank you, Mukesh. I think if I look at it from a corporate law perspective, I think the law is good enough. The problem is not the law. The problem is how you enforce it. Today, if you see NCLT, they are just too busy with IBC. They have no time, and then they are not able to look at the oppression and mismanagement issues. And therefore, this keeps getting delayed. And that is where the problem is. So I would say, if this has to be fixed, really, you need specialized NCLT tribunal looking after the minority rights. If you look at really, I don't know whether, Mukesh, you ever noticed that on the minority protection law, the World Bank came up with ranking. We are ranked 5th in the world. So as far as the law is concerned, we are up there. As far as the enforcement is we are bottom. And that is the problem. So instead of changing law, I think we need to make sure that whatever rights we have, we should be able to enforce. And therefore, what you require is specialist tribunal, specialist people who man there, and they are focused on getting things done. Like you mentioned about Z Invesco, which was a very crazy thing that a shareholder as a 10%, had a right to call EGM, and he just could not call. And courts kept delaying the matter, and at the end, the investor was frustrated and he sold off his shares and walked out of the deal. So what I'm trying to say is, it's not the problem with law. The problem is the bandwidth of the courts, and to make sure that they manage this law, they manage these cases properly, and it get adjudicated so that the rights which are there theoretically, the 4th, 5th, top law, we have the rights, but we can hardly enforce it.
Just very quick comment I wanted, point well taken, no changes from a legislative standpoint, but there is also a feeling that with the rise in shareholder rights, the rights given to minority shareholders from a statutory viewpoint could result in malicious and frivolous litigation. What are your views on that and any experiences?
I agree with you. Again, really, just because it can lead to malicious and frivolous litigation, there is no reason why it should not be extended to more. I think what is required is regulatory bodies, courts, they should be very active, and they should have the power to penalize Mukesh, if I see the problem in India is only that you are reluctant to impose penalty on frivolous litigation. And, and you and me understand that unless there is a commercial disincentive, you will litigate because that buys you time. So therefore, to look at it, changing law, giving rights to different interest group is a great idea, but making sure anybody who's frivolous should pay for it. And as long as you are able to do the same thing, I think if you look at enforcement of contract, the courts are reluctant to award interest and cost. And because of that, even a person who does not have a right keep enforcing contract and keep delaying enforcement of contract. So I would say it's the same problem here.
Sudhir, your quick comments on Mohit, and if there is any rebuttal, but I just also wanted to ask you a related question on the whistleblower mechanism as it exists today. Currently, SEBI is making the whistleblower mechanism available to what they call it as internal stakeholders and not external stakeholders. And there has been a recommendation again coming from SEBI that external stakeholders are not totally within their powers. So I just thought if you can just quickly react to what Mohit's observation was in the context of minority shareholders and your views on the whistleblower mechanism as it exists today, or rather how you would like to see it in the future.
So, Mukesh, I will say from a little broader perspective on corporate governance, because I look at it from a litigation lawyer's perspective and also somebody who practices sustainability a lot. So I'll just tell you, Z I won't mention because I represent them, so I have a conflict there. But I think what is happening in India, there is a wider discussion that why stock exchanges, why investment is not happening in a particular manner, especially the equity part, or the more and more people actually coming in the formal integration beyond fixed deposit and others and investing in the stocks, despite SEBI trying so many things, because there is a lot of secrecy involved, lot of curtains are there with regard to the entire corporate governance mechanism. And that's a little broader issue. Independent directors or directors who are there, they are the first people who should be the whistleblowers actually in the entire corporate governance structure. Most of the time they are also off guard or they are taken by surprises in any kind of situation when it really blows out of proportion. And the entire fear factor of not being accountable and not knowing the entire fact is something which is bothering the larger ecosystem of entire Indian thing. I think Mehra very rightly said that when you say about our trust factor, we are the fifth. I'm very happy to hear that. I was not aware about it. But when you see the trust factor in our corporate structure and also our governance structure, because now if you just touch upon this part, that what is the role of independent directors? If you are talking about beyond family, they are supposed to be the custodians for the entire shareholders, for speaking on behalf of everybody. But how many of them are in a position to be the real custodian for the corporate structure? That's my first worry on that.
Mr. Tandon, would you like to just quickly
I'll
offer a
just
comment
say
on both
something.
the aspects?
I'll come from the non-listed companies' point of view. And what happened, I've been general counsel for 3 decades now. And my submission here is, although we are not regulated by SEBI norms and other things, but we have very strong corporate governance structure. And the responsibility comes to us as a general counsel when we talk about compliances. So if you are right there on the compliances, I think the governance is taken care of. And here, what is the problem, in fact, in that part where the compliance we at times fail? Because the question of, the concept of 80-20 comes. We understand that 80 can be done, but 20 cannot be done. And for that 20, whether our board is taking the right decision. With your permission, Mukesh, I'll just come with, there's a book called Kathit Sarita Sagar, 11th century book. And that was written by Somdev. And there he talks about Vikramaditya and Betal issues, Betal Pachisi kind of stuff. So when he takes out that Betal, that's a problem for me, or the case study before the board, and he gives the right answer. Vikramaditya gives the right answer to that question. And when he gets the right answer, Betal goes away. Now, in the board, the question is, the right Vikramaditya are not there. They are not taking the decision on compliances. And therefore, this corporate governance structure is really required.
You know, you talked about corporate governance in the context of unlisted company. Do you think that the whole noise about corporate governance is restricted in India only to listed companies?
I don't believe so. Maybe from the legislature point of view it is, but we have our own. I would say that I was general counsel for Samsung for about 6-7 years for entire Southwest Asia. And our corporate governance was as good as any listed company, rather better than them.
How many listed companies do have whistleblower, unlisted companies have whistleblower mechanism? Point number one. How many unlisted companies actually take out a portion of their profits for CSR? Because in my view, these are two measurable tests for corporate governance. If I just take amongst various things, some unlisted companies or managements of promoters of certain companies, Mohit, and you can come in here over here, boast of independent directors, though they are statutorily not supposed to be providing it. Now the company law requirement is thrusting a related party transaction requirement even on unlisted company, but that's again statutory requirement. But how many unlisted companies in India, promoter-driven companies, Mohit, that you are aware of, follow corporate governance norms?
You know, one thing, if you look at the related party issues, if you look at the Companies Act, those laws are there, right? In this listed company, because of LODR, there are even more stringent laws. But what differentiate between the listed and unlisted space is that in a listed space, you have SEBI, which is a strong regulatory body, and which is getting into it, and people are involved, and therefore they're whistleblower or they're complaining. There are no external whistleblower, but there are proxy bodies and things like that. They're complaining and they're enforcing it. In private companies, which are not public or private company, but unlisted, the problem is there's no really regulatory on site. And you know one thing, basically, I think we all understand, if there's no regulatory strong supervision, there are not strong penalties, your market cap is not disturbed, there's not too much of incentive for you to, unless that's a part of an ethos of the company. So therefore, if you see a lot of these multinationals, which they have it part of the ethos, they can't go wrong, they follow it, but a lot of other people do all the related party through unlisted entities. So I would say the same thing is with CSR, because really there's nothing to lose. And I would say really, in my personal view, if you really need to improve the regulatory landscape to get to a $10 trillion, I think what is very important is to make sure that there is a strong regulatory body overseeing all these lapses. And that will be an important.
One of the instances I remember very clearly that in a healthcare segment, unlisted company, private equity invested, and even for the routine budget committee or any important committee which the investors have been participating and the regular management of the company was participating, a lot of related party transaction was happening. A lot of vendors were being taken, which were relatives of the main promoters. And this was within the knowledge of this private equity company too. And for 2 or 3 years, it kept on going on. And finally, when the auditors actually raised an issue, and internal mechanism was devised, and they were penalized for that. So the whistleblower actually, in that case, was the auditor which came into being. But I think you will surely like to know that when SEBI has taken a role of going after 1,000 companies to set standards for this country, if you are the 5th largest economy, and you are going to be 4th in next 1 year, the corporate governance will be perhaps more important than the environment and the social, the governance part. Because that is the message which they want to hear, that how much robust we are, how deep we are, and how much trust we can derive it.
Sudhir, I want
To what Sudhir said. In fact, today when I am in the investment banking kind of stuff today, what is required today, ESG has taken a lot of precedence nowadays. Now, ESG report is one of the really important criteria to give any financing done. So these things are taking up.
Sudhir, while we're on ESG, I just wanted to get your perspective on the current SEBI framework. There is a criticism that reporting requirements for ESG assumes that there is one size fits all, and there is very limited flexibility. And I know that there are several recommendations that have gone to SEBI, but what would be your blue sky thinking on what can be the future? Because this is a very important constituent of corporate governance
Yes.
and social responsibility.
So Mukesh, this is something I want to talk in detail. In fact, I'll say and encourage with Mohit sir being here, that law firms across the world are now making ESG reports, not only the audit company and consulting companies. In India, we make ESG reports as a law firm. And what has happened is we realized very early that every company which is interfacing development and environment today, or even if it's not doing environment, after John Kerry said that every lawyer is an environmental lawyer, virtually every regime from capital markets to merger acquisitions to private equity, there is some element of green funds or some element of green financing which is going to come. Developmental banks are asking for different kind of guarantees. So we were thinking ESG means environment. It's not. ESG actually across the world is going in a different direction where E is one part, but basically you are addressing to the 14 or 16 SDG goals which the United Nations have fixed up. Now the India opportunity is very unique. You are China plus, you are competing with Bangladesh and Vietnam. Their supply chains you have to confirm to Europe when they are asking you to give all those things. So S becomes very important for you. How your women procure those things, how many working hours they have, do you use child labor? And the board has to look after all these things very carefully in a proper scrutinizing manner, that are we adhering to all the women norms? So these are the things. When it comes to the governance part, that's a huge lack, which Mohit sir also pointed out. Why it's a huge lack? Because your entire country, everywhere from state to state, the laws change. The pollution control boards have different rules, regulations. The state filing authorities have different licenses, are very different kind of thing. So that needs a complete relook. Now, ESG reports have to be seen in a new dimension, that if you're going for expansion, you're going for board meetings, if you're going for funding also, one ESG report which really talks about your energy uses, your water uses, even if you are in an urban cluster, whether you have factories, how your women are, health issues are being conducted, how they are adhering to the POSH principle. So all of this actually is voluntary, and you are absolutely right. There's no single fit. There's no single law which adheres to it. And the good part is the corporates have addressed to it. So last year, top 100 corporates in India give their own consumption carbon footprint story. They all have published a report. This is for the first time any country has done. And seeing that sentiment, even the courts have started shifting towards that. Like the Supreme Court passed its first climate judgment, where they said solar power is equally important as saving wildlife. So both have to go hand in hand. Just 1 month back, they passed an order. So I think ESG in India will be a trend setter for rest of the country too, rest of the countries too, that how we will compete with, in post-China scenario, that I have a feeling that on social parameters we'll be better than Bangladesh, on environmental parameter we'll be better than most of the countries, and governance we'll have to really catch up. That's our difficult area.
Mohit, just your quick comments on one size fits all recommendations, and also on the CSR. There is a greater need being felt for voluntary compliance, because as you know, the law merely requires a disclosure of CSR and it's not mandated, though Ministry of Corporate Affairs has been picking up on large corporates who actually are not meeting the target. What has been your experiences with large Indian listed companies?
I would say most, at least my experience has been positive. Most corporates, at least the top tier corporates, are very committed. And if they are not able to spend, they spend it next year or things like that. So I don't see a problem. I think the problem is in the little bit lower down the corporates, where they feel that they can probably use this resource for growth and then they can do it next year. That's a problem, because I think it's all about getting the best out of the resource. But again, having said that, in my personal view, I think whatever said and done, Indian by nature if you have to get things done, you have to have a proper penalty. If you don't have that, I think we are great talkers, we'll talk about it, we'll say we are the best in the world, and we'll not comply. I think that's the problem. That's what I have seen it all my life. Like ESG, Sudhir is very passionate, but right now you can't export to Europe because they will not let you export, because they are making sure every importer is ESG compliant. And because of that, only those corporates in India who are exporting to Europe are complying. The rest are not complying. Because really, at the end of the day, what I have seen in my life is anything which is great theory, nobody cares about it, everybody talks. And lawyers are good to talk. But anything which hurts your wallet, everybody follows it. Like if you remember, corporate governance was a useless word. Everybody who thought that it's too much of cost, why do it? Then the era came when the private equity showed up in 2003-4, and they started giving more value to higher governance companies. And then suddenly the promoters started saying, if I take $100 out, I actually lose 1,000 on my valuation. So why should I take it out? So therefore you have to, in this country, everything has to be economically incentivized. As long as you economically incentivize, I always feel that you can't enforce contract in India because you make more money by being breach of contract. And that's the issue. I think in my view, that is what is required, is make sure that every guy who uses it frivolously, you punish it, and if you see today, if you look at the US, any company which does money laundering, they don't put the guy behind the bar. They make the company bankrupt. Here, when you put a guy behind the bar, I remember one of the promoters I was talking, he said, "Kya fark padta hai? Why are you so worried? Maximum kya hoga, I'll go inside and then I'll come out." But if the company goes bankrupt, then the whole family goes bankrupt, right? So I think in my view, the regime has to change. It has to hurt. I think in my view, that is the only way.
You mean the current framework is not?
Current framework is all based on not penalizing. And I think in my view, you have to economically penalize people, not penalize by putting behind bars. That doesn't solve it.
More importantly, Mr. Mohit Saraf seems to be in favor of very stringent conditions and all that. And I have always been against, you see, over-regulation. Or regulations, you see, do not solve the issues. It has to be like a change in the mindset. Therefore, having more penal provisions would not be a deterrent. People will always find ways and means, you know. No one is allowed to murder anyone, but murders still take place. Therefore, what is required is not, again, regulations and regulation. That will create more disputes also. Good for lawyers, but bad for the country, bad for the economy. There has to be some mechanism to change, to have the change of mindset. And Mr. Sudhir Mishra rightly pointed out that there is some movement, you see, so far ESG is concerned. People are becoming conscious of the hazards and perils, you see, which you see not us, but our next generations face. Therefore, that sort of impression, feeling, that has to be created.
Penalty provisions are one provision which really we hate. We are scared to come to the board and inform them this is the penalty which you are going to be imposed. But if you see from the other side, how to save the penalty becomes the lawyer's paradise. Right? But what we require here, as I said and gave you the example of Katha Sarit Sagar, that we are not having the right Vikramaditya on the board. And therefore, when compliance becomes loosened, and therefore the penalty provisions taken. You know? So what we require to do, I think we have enough laws, sir. We have enough laws in the country to be the best. Just comply with those laws. That's what is required.
So every time I have a call,
Sir.
with a GC,
Correct.
both domestic and international, you know what they ask me? What is the worst case?
Right, right.
If I say the worst case is a $200 million, they'll stop and follow it.
Correct.
The minute I say the worst case is one officer will be put behind the bars, not a big issue. So that's the reason I'm saying that what hurts is pocket.
Correct.
Otherwise, it's all great job. And I think in my view, if you look at it, is whether it's a corporate governance issues, when you start doing token penalty, it doesn't move the needle.
Correct. Correct.
When you put people behind the bar, which is penalty, which I am not at all. I'm saying let commercially they pay. Like if you have spoiled the environment, then whatever you have done, you pay that. And that's what typically globally people do. Right. That if they do something wrong, they pay to that extent to fix that problem. And you don't token penalty, because I think our concept of penalty 73, section 73 of the damages in Indian contract is all outdated. Correct. And because of that, we actually have a field day on all these issues because we can always find a way.
Okay.
I think Mohit is trying to say that use penalty as such a big deterrent that you make people comply with it. Economic penalty. Yeah.
So,
Sorry, Sudhir.
Almost just echoing what Mohit said. So there is one company, which is a very big multinational company. They were involved in a plastic transition. So our country actually has done an amazing job on the plastic and packaging transition. Very few companies, even in Latin America and Europe, have managed to do it. So the General Counsel, the Global General Counsel, actually said, why should we do it here? We are not even doing it in America. So we had to tell them that different pollution control boards are stopping your packaging and you will face bigger problem. So you will have to set standards in India. Now my one problem with the corporate world is, and the corporate governance is, that our boards are not told the truth and are not warned in advance. And that's the biggest thing. In fact, Supreme Court, our Chief Justice is sitting here. There was a matter where for the first time it was seen in the Supreme Court only, that is cement companies, environmental data, were from Desert National Park, but the case was about Northeast. So you can imagine, they only pointed it out what is happening. So we just take things for granted. As it was said, if it has economic consequence, we just turn blind, we stop doing any job of whistleblowers. And now the change is happening because more than the prosecution, more than the court actually coming after you, it's the regulation which is taking care. Regulatory bodies have taken, and SEBI has played a big role there, and you are being watchful about it.
In one of the cases, in Legal Metrology Act, for us in the Samsung, for us in Samsung, Legal Metrology Act was a packaged commodity, that's what we are selling. And if we submerge, or if one of the things or six, are not written there properly, then there is a provision of going to jail. But who will go to jail? There is a penalty provision as well. But if the director will go to jail after 3 commission of events, right? But it was not being complied properly. And once I had, as a general counsel, advised my management, if I have a Korean director who is responsible for legal metrology, everything come to a state.
Absolutely.
So at times, penal provision really works.
Sure. Thanks for the intervention. Our fourth element, and I wanted to, before the buzzer goes off, fourth element of the governance was on independent directors. We are now seeing 2 decades of completion of independent director regulation from a SEBI LODR perspective. And we are also seeing one major rehaul of independent directors because of the 2013 Companies Act. What is the quick verdict of each of you? Where are we on a scale of 1:10? Satisfied, a lot to be done, dissatisfied? Because I did hear some comments, are independent directors truly independent? Mohit, first.
So basically, you're talking about whether
Quality of independence.
Quality of independence director. I would say not satisfied, because you know one thing, the problem, like people like me, I'm on the board of only one company. I'm just very reluctant. And it's not an easy thing to be on the board because the level of information you get, there's virtually no application, and then you are liable for everything, or your knowledge is presumed through the board process. So it's a very difficult job to be there and to understand, and obviously to, even for lawyers who are a little bit more versatile to understand, but to understand accounting issues and things like that, it's not an easy job unless they have independent advisors. I think in my view, that is what is required. Right now we penalize independent directors. The institution is building, but it's still a long way to go.
Sudhir, your experience?
Yep, I would say that it's a long way to go, and we really have to go beyond our cluster of people we normally appoint for reasons best known to the company and best known to the promoters, especially the non-listed ones. Even in the listed one, we have a remote system of appointing people, which is not very transparent, and I think a lot has to be done in that area. It's not risk-free also for real people who can make a difference or play the role of being whistleblower, to be appointed, or who look forward to be appointed. I think these are the areas we need to really work, and that's why I say that the ESG, the G part is the work in progress.
Your experience?
Yeah, I agree. G part is certainly work in progress, but in a scale of 1 to 10, I'll give 6 to 7.
So, Mohit, before we end the session, I completely echo your view. I chair audit committees for 4 listed companies, and trust me, a day before the audit committee and the board meeting, I don't do any client work because the volume of papers that hits my table is so overwhelming that despite having practiced as a chartered accountant for 2 decades, I still find it difficult to grapple with the host of regulations you have to deal with.
So I think unless you're an auditor, really you need a lot of independent advice, and which typically no board gives or independent directors. And therefore, for them to apply themselves and really do a good job is very, very challenging. So I don't really blame them, but I think that we have to build an institution where they get independent advice so that they can apply themselves well.
Well, our time is up, just at the right time. Our time is up. Thank you very much. I would like to thank our esteemed panel, and with that, hand it over to the organizers. Thank you.